Good afternoon, everyone, and welcome to the webinar, Criminal Meets Civil, Coordinating Our Response. My name is Charlie Whitman-Barr, and I'm an Associate Attorney Advisor at Equitas, the Prosecutors' Resource on Violence Against Women, and I will be moderating today's webinar. This presentation will highlight the importance of coordination between prosecutors and victims' civil attorneys. The presenter will discuss the potential for identifying crimes not yet reported to law enforcement, and will explain how prosecutors and civil attorneys can work together to identify helpful evidence that will be admissible in the criminal case. Today's presenter will also explore ways in which civil proceedings in family or other civil courts can support the victim while the criminal case is pending. Before we begin the substantive portion of our program, I will provide a brief overview of our iLink webinar service. You can listen to this webinar either via computer or conference call. For best use of iLink, I strongly recommend calling in from a landline to the conference line at 530-881-1212, passcode 202-731-738#. That number is in the upper left-hand portion of your screen. If you're using a mobile phone, please do not use the speaker option, but listen in with an earpiece if necessary. All call-in participants have been muted for the duration of today's presentation, and today's presentation is being recorded for later viewing. To connect to internet audio, please click the Connect button on your start screen. If you use this audio option, please do not also call into the webinar. Only do so if you experience technical difficulties. If you do experience technical issues during today's presentation, you can use the iLink hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen above the presenter's photo and to the right of the conference call number. You can also contact iLink directly at 1-800-799-4510. Throughout today's webinar, we invite you to post questions and provide comments about the presentation. And you can do that by private chatting me, Charlie Whitman-Barr, in the private chat option, which is in the bottom left-hand portion of your screen. For today's presentation, public chat has been disabled. Today's presentation is hosted by Equitas, the Prosecutors' Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you following today's presentation. In addition, as I mentioned before, the webinar is being recorded for later viewing. Equitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Equitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. Equitas staff conduct legal research, provide 24/7 case consultations, host specialized and state-specific training events and webinars, and provide individual experts to jurisdictions and organizations. And we also publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter is Teresa Garvey, Attorney Advisor at Equitas. Prior to joining Equitas, Terry worked for 22 years as an assistant prosecutor in Camden County, New Jersey. For 9 years, she was assigned to the Domestic Violence Unit, and for 5 of those years served as Deputy Section Chief of that unit. Terry works closely with the Victim Witness Advocacy Unit to provide education to the public and to community leaders who come into contact with domestic violence victims. Her jury trial experience includes the prosecution of domestic violence crimes, sexual assault, and other violent crimes, drug offenses, property crime, hate crime, and official misconduct. Terry also has extensive appellate experience and has briefed and argued numerous cases in the appellate courts in New Jersey. As I mentioned before, Terry's full biography will be emailed to you following today's webinar, along with a PDF of today's presentation. I'd now like to turn the substantive portion of our presentation over to Terry. Thank you.
Thanks, Charlie. Welcome, everyone. Good afternoon. Hope everyone had a good holiday. What we're going to be talking about today, as you know, is how criminal prosecutors and civil attorneys who represent victims in civil proceedings can kind of pool their resources, improve communication, and enhance their ability to create a victim-centered response to domestic violence. And I kind of stumbled on the helpfulness of that kind of approach by accident in a few of my cases when I was a prosecutor, when I was a domestic violence prosecutor. I had a couple of cases, particularly a couple of very serious assault cases and a couple of stalking cases where the victim's civil attorney was of incredible help to me, and I like to think that I helped make their job a little easier as well. Certainly, to the extent I was able to help their clients, they appreciated it. And I think we all walked away from those experiences feeling like we could approach each other, and that's what we kind of want to foster here today. So our learning objectives are going to include identifying relevant information that will enable us to prosecute cases with or without the victim's participation, recognizing that many civil attorneys do not operate under the same kind of evidentiary constraints that criminal prosecutors do with Crawford and so forth, and they may need to be educated on some of that. Not that they're unknowledgeable, but they don't always understand the specific issues that arise in criminal cases. Likewise, we don't always understand as prosecutors, or I did not fully appreciate all of the considerations that went into what civil attorneys were able to do. So we want to be able to appreciate the professional and ethical considerations that go into our ability to work together, which does not mean that we can't still be communicating. We may be able to communicate more at arm's length, but it's important that we recognize that when that isn't happening, it isn't just a matter of refusing to assist another attorney who's trying also to help the victim, but it may be for very good reasons that we just aren't understanding yet. And we want to facilitate communication between the civil and criminal side of the bar and enhance victim safety by building those relationships so that civil attorneys will feel comfortable approaching prosecutors, and likewise prosecutors will feel comfortable reaching out to the victim's civil attorney, and we can foster those relationships. So I'm going to start off with, unfortunately, we don't have the capability of playing a video here, but this is a reference to a video that some of you who have been to Equitas presentations or possibly other presentations that have used this video have seen. It's the Rachel video. And it starts off with Rachel telling her friend that she's called 911, he's hit her one time too many, she finally called the police and he's locked up. And what unfolds from there is that Rachel, in the course of her life, her day-to-day life, is increasingly bombarded by other things that are going on. And some of those things are civil legal matters, including things like obtaining a protective order. She has landlord-tenant problems because they are trying to evict her because since her batterer is in jail and no longer paying child support, she can't pay the rent anymore. She's having credit problems. Her creditors are hounding her. She's getting calls that the utilities might be shut off. She's going through divorce proceedings with her batterer, and that's a whole additional set of considerations, including wrangling with the batterer over custody and visitation issues, child support. There are custody and visitation matters simultaneously going on in the divorce court and in the protective order proceedings. And she, at some point, is getting contacted by Child Protective Services, either because the batterer has reported her or someone has reported to CPS that the children are in a dangerous situation. So she's got a lot on her plate. You can see here in this slide, you know, this is a lot for somebody who has no outside life to be dealing with. I would not want to be dealing with all that stuff. And she is dealing with a loan with 3 children that she's responsible for. Oh, and by the way, in addition to all the legal issues she's handling, she also has her children with various doctor's appointments, school obligations, after-school activities. Can dad do this? Can mom do that? Why isn't dad coming home? So she is really, really overwhelmed. And actually this video ends with a note from the caseworker saying that Rachel has become increasingly uncooperative. And we really kind of dislike that term uncooperative when we're talking about the victim's behavior, because that sort of implies that it's just being obstinate or difficult. And what we really have is sometimes a reluctance to participate any further in the process. It just becomes increasingly overwhelming and difficult for victims for a variety of reasons most of which we are quite familiar with. And incidentally, if you want to see the Rachel video, I believe it's posted online. Praxis International created the video, so if you go to their website, I believe it's available on there. It's very powerful. So one of the things that we can take away from Rachel's experience and from our own day-to-day working with victims in domestic violence situations is that victims need a lot more than just having more legal stuff shoveled on them. They need to feel safe and to be safe. They need to know that they're safe, their children are safe, their pets and their family members are safe. They have to know that they're free of intimidation, and we have to do whatever is necessary to make that happen to the extent that we're able to. Victims need to be informed. They need to know what's going on with their cases. Often they have misunderstandings about where criminal ends and civil begins and vice versa. And they confuse the prosecutor sometimes for their civil attorney and wonder why we aren't able as prosecutors to accomplish some of the things that maybe her civil attorney is in a much better position to address. But they need to know what's going on. They need to know what's going on with their civil cases and with their criminal cases. They need to be more than just a case in somebody's caseload. They need individual attention, personal responses that will take all of their circumstances into account, all of their various challenges that they face in terms of employment, income. Economic issues can be huge in these situations, particularly if she's economically dependent on the batterer. And victims need to feel like at some point they can regain control over their lives. The entire legal process, whether it's civil or criminal, takes a lot of the power, the individual power, out of the hands of the person whose life is most affected. And it puts it in the hands of attorneys who want to do the right thing, who want to help, puts it into a legal system that's not always created to be personal. Often is a lot of the aspects of the system are in place to make it efficient. And efficiency is important too. We don't want cases to languish forever, but overall, it's taking a lot of power away from victims. So we want to give that power back to them, and we want to treat them in a way that honors their individual circumstances. So one of the best ways that we know of to address all of the multifaceted aspects of the criminal justice response is to engage in what we call coordinated community response, or CCR. And some of the goals of that are to provide comprehensive services, one-stop shopping in some cases where for jurisdictions that have family justice centers, where the victim may be able to get a protective order and also report a violation or report criminal offense at the same time, get any other kinds of advocacy services or other things that they need, so that we can all in the system exchange information with each other. We can cross-train each other so that we understand what law enforcement's challenges and issues are, so that we understand what advocates are dealing with, and so that they can know what we can provide that will help them do their jobs, and basically so that we work together. And it brings together, obviously, a lot of different system actors, advocates, law enforcement, maybe healthcare. There are the courts. And this is sort of a traditional outline that we've used in the past, showing the intersection, the web, with the victim in the center, because we always want to maintain that victim-centered response. all the ways that these various entities interact with each other and with the victim to hopefully provide a good, effective response. But there is something missing here, and what's missing in many cases is the victim's civil attorney. And this may be a family court attorney or a family law attorney, matrimonial, child custody, and so forth. Could be someone who specializes in landlord-tenant proceedings or debt issues, bankruptcy attorneys. There are a lot of legal actors out there who might be assisting the victim or might be available to assist the victim. And if we aren't including them in our CCR response, then we're missing out on important contributions that they can make and important contributions that we can make to ensure the overall well-being of victims. There are often, in these cases, as we've seen, parallel proceedings going on. There may be criminal and civil proceedings going on at the same time, including a criminal case, protective order proceedings, divorce, custody, or support proceedings. And often what happens in one venue will affect, to one extent or one degree or another, a greater or lesser extent, what happens in the other venue. It could be that if a victim receives protection from a protective order, we won't have to necessarily worry about that so much in terms of bail conditions or sentencing. It depends. I mean, each case is individual. But it can certainly impact what's going on in the other case. And often there will be overlapping evidence. It may be that an abuser who has punched holes in the walls is causing legal problems for the victim who is now being pursued by the landlord for damage to the apartment. And that evidence of the damage and the police response, those police reports and so forth, may help her in her quest to get free of responsibility, financial responsibility for something that she did not cause. So it's important to know that that all of this is taking place simultaneously, at least potentially. In Rachel's case, among her civil matters are protective orders, landlord-tenant problems, credit problems, divorce, custody, visitation, and child protective services. And this is a pretty typical list of the kinds of things that a victim might be facing when they are in a domestic violence situation and the abuser has been arrested. Now, if we think about it, victims' lawyers have a lot of information that could potentially be useful in a criminal case, in the criminal proceedings, or might be important not even necessarily to introduce in the criminal proceedings, but just to be aware of so that we aren't working at cross purposes. They may be aware, for one thing, about more of the history of the relationship. Sometimes police reports are rather sketchy. Sometimes the officers aren't able to do as detailed an interview with the victim as they would like to. Sometimes the victim's hospitalized and maybe not in condition to really talk at any great length when they do the initial response. But the victim's attorney, if he or she has been representing the victim throughout prior proceedings, may have a better handle on what the history is of this relationship. They may know about the history of violence in the relationship. It may be part of the divorce allegations. The civil attorney may have already done some investigation. They may be aware of violence in prior relationships. And remember, a victim may be more forthcoming and often will be more forthcoming with their own attorney than they will be with the prosecutor because their own attorney is working in their own interest. They don't have any other axe to grind other than to get the best possible result for them. And they're protected by confidentiality. So that's one of the things we're going to talk about in a little more detail is that whatever the victim tells her attorney, she knows it's going to be kept confidential and not released and not used in a way that maybe does not advance the goals that she has for resolving her issues. The attorney also may have done some preliminary risk assessment or maybe an in-depth risk assessment and be familiar with a safety plan that has been created for the victim and may know, for instance, whether there's a gun in the home. And part of what we can do when we're interacting as prosecutors with civil attorneys is to educate them about what we know about the escalation of violence, because it may be that the average matrimonial lawyer it may be that domestic violence or serious domestic violence may only be an issue in some of their cases. So they may not have the expertise that prosecutors who do it every day may know about. But they may be in a position to know whether there's a gun in the house. They may also be aware of a lot of evidence that may be useful or potentially useful or leads even to evidence that the prosecution can then pursue and advance the criminal case. The civil attorney may learn in the course of representing the victim that there are unreported crimes that have not yet been the subject of a criminal complaint or any proceedings, including threats of violence, possible sex offenses, including sexual assault or criminal sexual contact, abusers. There's often a lot of cross-offending in intimate partner violence with intimate partner sexual violence. And the civil attorney may be the first one to hear about that, again, in part because of the confidentiality issue. They may be aware of stalking behavior, which maybe nobody has really pegged yet as stalking in violation of the criminal statutes, because, again, the civil attorneys are more focused on dealing with the victim's civil problems, but they may learn of behavior that satisfies the statutory definition of stalking. They may be aware of other assaults, kidnappings, or restraint, burglary. It's not unusual for spouses on the road to divorce to break into each other's homes, so she may be aware of those issues, witness tampering, and criminal mischief. These are some of the crimes that they might find out about in the course of representing the victims. So we're going to examine in a little more detail how this might be approached in the context of an actual case. We are going to talk about Cindy and Jason, who are a married couple who are going through a divorce at this time. And the attorney, the civil attorney, is also representing her in a protective order hearing, which is scheduled for the following week. The facts are that Cindy was granted an emergency protective order as a result of an assault, and the hearing is scheduled for next week. In this particular instance, the police responded after their 5-year-old son called the police. The husband, Jason, then strangled Cindy until she briefly blacked out, as she tells her lawyer. And Cindy was treated at the hospital and released. And Jason was ultimately charged with second-degree assault, which is, we're going to assume, is a fairly serious degree of aggravated assault. The civil attorney, in the course of the interview, asks about the history of the relationship. And Cindy tells the attorney that Jason has always been jealous and controlling, which is, as we all know, is typical of domestic violence relationships, and that the physical abuse started shortly after Cindy became pregnant. He has been isolating her from her friends and family. He won't let her call her mom. He won't let her see her sisters. He thinks they're a bad influence, that they are saying bad things about him. She says that her sister and mother have seen bruises on her, and she has confided in them. So Jason's fears are not completely unfounded. A neighbor in the building called the police once last year during a fight that they were having, is how she described it. But she told the police that everything was okay, and the police left without anyone being arrested. Last month, during an argument, he pointed a gun at her and said, "I should blow your effing head off." The next day, she hid Jason's gun in the attic, and so far she doesn't think he's noticed that it's missing. And she is scared to death and wants that gun out of the house. Having the gun pointed at her was pretty much the last straw. When the attorney specifically asks, and this is important to know, is this is not typically volunteered by victims, Cindy says that Jason sometimes makes her have sex. Last week, she said he was drinking and he slapped her in the face when she refused, after which she says she let him just to get it over with. And she tells her lawyer, "I never told anyone about this. I'm too ashamed and embarrassed." Now, one of the first questions that probably will arise with an attorney who has heard this kind of information from her client, that she is being raped on at least an occasional basis, is should this serious crime be reported to the police? And there are a number of considerations or questions that might go into answering that question, and it will differ probably from one victim to another, what is going to be in that victim's best interest and what that victim actually wants to see happen. And one of the questions is whether there's already an open criminal case, because if there is, then it may be that additional charges would be appropriate. He's already in trouble. He's already possibly going to prison for what's been done to him. And maybe it's best for the prosecutor to hear the entire story and for the jury in the criminal case to get a full and clear picture of what this victim has endured, to explain any behaviors such as why she hasn't left, why she may have gone back to him, the kinds of behavior that calling an expert witness is often helpful to explain. There is a potential for additional evidence that might be introduced under the Rule of Evidence 404B, which allows prior bad acts when they bear on motive or intent. It may be that he uses sex as a weapon to prevent her from disclosing the other kinds of abuse, or vice versa. It can also help to explain why a victim might have delayed reporting a prior incident or later incident. So all those things can be important to shed light on the facts of the original charges and to present a full and accurate picture to a jury to assist them in assessing the victim's credibility. But the bottom line usually for a civil attorney is whether filing those additional charges is going to benefit the victim. What's in that victim's best interest? Remember, a civil attorney representing a victim in a civil case does not have an obligation to report, except possibly in cases of child abuse. They may be mandatory reporters in that situation, but generally speaking, they don't have a duty to report to the prosecutor, and they can advise their clients, although they can never advise them to lie to law enforcement. They may advise that client, after talking it through with them, that it may not, in fact, be in that client's best interest to file this additional report and go through what is involved in pursuing a sexual assault case. So these are the kinds of things, though, that are worth exploring if you happen to be a civil attorney. There are limitations on the civil attorney, as we've alluded to, on the civil attorney's ability to cooperate with the prosecution. First of all, they are bound by that confidentiality. There are very limited circumstances, which we'll go through in a moment, in which the victim can the victim's attorney can disclose information without the victim's explicit consent. It may be, as we talked about, that the cooperation may not be in the client's best interest. The attorney, the civil attorney, generally has a duty to, unless it conflicts with other ethical obligations or with other law that controls their behavior, they have a duty to pursue their client's wishes within the bounds of the law. So if the client does not want that disclosed, the lawyer's duty is to do whatever they can legally to prevent that from being disclosed. And it's important to know, too, that sometimes what happens in a criminal case may adversely affect the civil case. So those are all considerations that a civil attorney is going to go through in determining whether they can, in fact, cooperate with the prosecution. Now, cooperating with the prosecution is a different story from just having basic communication, because there may still be other kinds of communication that's useful that doesn't involve violation of any of the obligations that the civil attorney has. So most states have some version of the ABA model rules. The ABA model rule states under the heading of confidentiality that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, which means they also have to understand what it's going to mean to the client, or unless the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. Paragraph B being that a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes is necessary to, among other reasons, to prevent reasonably certain death or substantial bodily harm. So clearly, one of the things we have to look at, because there may be ways that the civil and defense sides can help each other or help the victim by working together or communicating on whatever level is appropriate, that we have to build these relationships. We have to build familiarity, we have to build trust with each other, and respect, mutual respect for the respective roles and obligations of each side. Now, prosecutors, in the course of sitting down with with the victim's civil attorney, can explain the problems and the issues that they have in a particular criminal case, why they may not be able to use certain items of evidence, or why a case may be more of a challenge to prove. For example, civil attorneys, because they don't have to understand it, often don't have a really in-depth grasp of what the limitations are imposed by Crawford versus Washington and its progeny. Crawford, just as a quick refresher or explanation, Crawford is the case that says that unless a victim is on the stand or a witness is on the stand to testify subject to cross-examination, a testimonial statement made by that witness out of court is not going to be admissible in lieu of the victim testifying. If the victim is on the stand, then the only constraints are the usual hearsay rules, which civil attorneys understand as well as criminal attorneys. But the problem is with that confrontation clause issue, which is what Crawford is all about, you have to have the victim at least on the stand before you can take advantage of many of those hearsay exceptions. Civil attorneys also normally operate on a preponderance of the evidence standard. Criminal cases, of course, have beyond a reasonable doubt, and that additional burden in a criminal case may make certain charges or allegations more difficult to prove in a criminal case. On the other hand, they may be substantially easier for a civil attorney to prove, and it may be that the defendant will testify in a civil proceeding, and it's possible that that testimony will be admissible in a criminal case. That is depends on the law in each individual state, but it's a possibility. It's just an example of how that shifting burden of proof may impact the criminal or civil case. Prosecutors can also explain any reasons for delay, why the criminal case may be taking longer to go through the system, and they can explain what efforts are being made to expedite the case. If it's very important for a victim to have her criminal proceedings concluded as quickly as possible. It may be that the civil attorney can sit down with the victim and discuss whether it's in the victim's best interest to provide additional information that will enable the investigation to proceed more quickly. And the prosecutors can also work to understand the civil attorney's position and constraints. We can be, as prosecutors, not impatient or dismissive of a civil attorney who is not forthcoming, recognizing that they are fulfilling their role, assisting the victim in their own appropriate fashion. Civil attorneys can, with the consent of the client, advise the prosecution of evidence that they've learned about. If there is information that might qualify as a non-testimonial statement under Crawford v. Washington, I'll tell you a little bit more about that in a moment. It may be that there is some of that evidence that can come in, whether the victim testifies in court or not. They can also, with the client's consent, advise whether the victim is feeling comfortable about proceeding and testifying and participating in the criminal case. So, again, civil attorneys don't want to put their clients in a precarious position, but with the client's consent, they can explain that they are not comfortable testifying, they're feeling very intimidated, and that may be a heads up to the prosecutor that this victim may, in fact, not be able to proceed and may adjust their investigation accordingly. Civil attorneys can, I think regardless of whether their client consents or not, still exchange or obtain from the prosecutor basic scheduling information, where are the proceedings at right now, what's going on right now in court, when is your motion being heard, those kinds of bits of information. They can find out what's going on in the criminal case, and at the same time they can share what's going on in their courtroom, in their venue. They can also find out about victim compensation and advocacy services that may help their clients. So, and I think that does not cause any kind of improper disclosure of victim information if they just request that basic information so that they can sit down with their clients and talk about their clients' options. You can also discuss what's coming next, where do you think your case is going, can talk about typical plea negotiations. For example, in a lot of jurisdictions, there is sort of a sense of what is an appropriate plea offer, what we'll probably offer, what might be the ultimate outcome, and to find out what's going to be acceptable to the victim or what the victim really wants to have happen. And again, it's not that this information has to be obtained from the civil attorney. It may be that always the best approach is to talk to the victim personally, but victims may be feeling overwhelmed and intimidated and distracted when they're in criminal court talking to the prosecutor, and it may be that they can talk more comfortably with their civil attorney, who in turn may be able to communicate more effectively with the prosecutor than the victim would be herself. Civil attorneys can provide updates about what's going on after they've gone in for the final hearing on a protective order. Here's what happened. Here's what kind of protections she has now. Here's what her current concerns are. And we can talk about such things as bail conditions, whether the victim does or does not want to have contact with the defendant pending the criminal proceeding. It may be that she has to go into court and tell the judge that she wants contact, but the civil attorney may tell you that she has to do that to protect herself, but in reality she does not want that. So that may be something that the civil attorney might be able to assist with as well. So some of the things that might help in a criminal case, obviously, would be additional witnesses. It may be that the civil attorney is aware of certain witnesses not always fact witnesses, because usually the police and investigators get pretty good identity information on who the actors are in a criminal case. But there may be people who have corroborating information, information that would be useful, information about prior bad acts, for example, that the prosecution would not know about unless it was brought up. So there may be witnesses who would be able to provide a non-testimonial statement by the victim, which is typically those kinds of witnesses would be non-official witnesses, not law enforcement, not in a formal proceeding, but a friend or a family member who the victim may have confided in immediately after an assault happened. They may have gotten frantic phone calls from the victim in the middle of the night that would come in as excited utterances. And those would be considered non-testimonial because they are not made for purposes of potential future prosecution. They may be aware of these prior crimes, possibly acts of intimidation, threats that have been made, damage done to the victim's property, threats made against family members or pets, various things that the defendant may have done to prevent the victim from coming forward or from disclosing what has happened to them or from testifying in court. So in addition to providing information that might be useful in, under Crawford, it's also possible that some of that might help to support a motion to admit evidence under forfeiture by wrongdoing if the victim is unable to proceed in the criminal case and declines to testify. So that's some of the additional kinds of information they may be aware of. Financial records. Often there is discovery exchange in the course of various civil proceedings, and there may be financial records that the victim's attorney has which might disclose who controlled the money. It might also be that the defendant has responded to various requests for civil discovery that might be useful evidence in a criminal case. And pro se filings. I've had many cases where defendants are very litigious, and they will file pro se motions and arguments and send letters to the court and letters to the civil attorney, and a lot of that can be a gold mine, in my experience. Often these matters are very arrogant and very self-confident, and they will oftentimes disclose information that will be very helpful in a criminal case and or show their state of mind towards the victim. So there's a number of ways in which that can be very useful. We talked about non-testimonial statements that might be admissible under a hearsay exception, including family and friends, also employers or medical professionals. If the victim on prior occasions had to receive medical treatment for assaults and she told perhaps a medical professional how she received those injuries, those would also be considered to be non-testimonial statements. So that can be very helpful. And as we said, evidence supporting a finding of forfeiture by wrongdoing. Forfeiture by wrongdoing is a rule of evidence in most jurisdictions, either in the rules of evidence themselves or it's been adopted by case law as an equitable rule of evidence. And what it says is that if the defendant or one of the parties is responsible for a witness not appearing in court, that any out-of-court statements by that witness or victim can be admitted without the need for confrontation or cross-examination. The theory being that the defendant's opportunity to cross-examine has been forfeited because he's the one responsible for putting the victim in the position where they're not in court to be cross-examined. So the leading U.S. Supreme Court case on that, Giles versus California, involved a domestic violence homicide. And in that particular case, the court held that even though the defendant admitted shooting the victim, although he was claiming it was in self-defense, that alone was not sufficient to qualify that evidence to come in as under the forfeiture by wrongdoing exception to the hearsay rule, because there's also the obligation to show that in committing the act of violence, the homicide, the defendant had the intent, one of his intentions at least, had to be to prevent the victim from reporting the offense. And there's a lot of useful language in Giles versus California about how the defendant's intention can be discerned. And it includes things such as showing that the victim is in what the court referred to as classic abusive relationship, the classic power and control relationship. And so to the extent that the civil attorney might have evidence that would support that kind of a finding, that might assist the prosecutor if push comes to shove and the victim is unable to testify in court, in proving the case without the victim's testimony. Again, civil attorneys can, of course, never advise their clients to disregard the court subpoena or refuse a lawful subpoena summoning them to testify, but the reality is that in some cases the victim will simply refuse, and so it's helpful to be aware of that information. And we've talked a lot about what the civil side can do for the prosecution, but by the same token, often information that is in possession of the prosecutor may prove to be helpful in the victim's civil proceedings. For one thing, prosecutors have available to them certain means of obtaining evidence and certain kinds of evidence that may not be equally available to a civil attorney. For one thing, we have things such as search warrants, which can enable us to obtain evidence by court order. And oftentimes that's used to obtain evidence of online activity, emails, email account information, social media posts. We can obtain Facebook data directly from Facebook that will show the IP of the person posting. But that's generally not available to a civil attorney. Now, we certainly as prosecutors are not able to simply use state resources and the power of the prosecutor's office to obtain information for the advantage of a victim in a civil proceeding. But given how overlapping so many of these cases are, there's certainly no problem with our advising the victim's attorney of what is in the state's file and letting them know that certainly they can subpoena that information by issuing a subpoena ducus tecum, which means bring the evidence with you to the investigator or police officer who obtained that information. So that can be very useful in a criminal case if the victim is being stalked, if there are various kinds of proofs that are needed to be obtained in that way. It's also likely that we would be able to request restitution or bail or probation conditions that are going to assist in the civil realm as well. We may be able to obtain conditions that maybe a family court would be reluctant to grant because they have not heard all the evidence that the criminal court has heard. So we may be able to provide some kinds of relief that will be easier and quicker to obtain than the civil attorney would be able to obtain in civil court. It's important for us to know that the perspectives of the civil attorney and the criminal court prosecutor may be rather different. And it's helpful if we sit down and have a conversation to find out what each side is most concerned about. What is the primary goal here? What do we most want to achieve? And if we know that, then we can work together more effectively. It may be also that if we improve our communication and are forthcoming about what we want as prosecutors to achieve, that may put the civil attorney in a better position to explain that to their client, thereby improving the likelihood that the client actually will participate in the criminal proceedings. If they know what our goal really is, because they may be listening to the batterer, and the batterer may be telling them things like they want to send me away for the rest of my life, they want me to do 40 years, and maybe it's a likely probation case or probation in county jail or a minimal prison sentence. You may know that that's what the real likelihood is. So we can uncover some of those misconceptions that the victim may be operating under and reassure them that, in fact, here is what our actual goals are and what's actually likely to happen. And that may make the victim much more comfortable about participating in the case. By the same token, sometimes prosecutors may be hesitant or skeptical about a case, and the civil attorney can help their client by explaining and maybe and advocating for their client for a particular result. And it may be that they are going to be able to persuade the prosecutor to take a second look and possibly take more fully into account the victim's concerns in deciding how to dispose of a criminal case. So we're going to return now to our hypothetical about Cindy and Jason. And we're going to assume, that after some conversation, some in-depth discussion, and maybe Cindy takes a couple of weeks to think about it, she comes back to her attorney and she states that she does want to cooperate with the prosecutor's office. She wants to participate and testify in court, and she wants Jason to be held accountable for threatening her with a gun. She wants that gun taken away. But she does not want him charged as a sex offender. She feels that that is not going to be helpful to her or to her family or to her family's future. And she says she really doesn't feel comfortable testifying about the rapes, and she wants to think about it maybe a little longer, and if she needs to, she'll let her lawyer know if she changes her mind. But for right now, she's happy to go forward with the assault charges and the threats, but not to disclose the sex offenses. And that is a pretty typical, I think, kind of response from a victim who is in that situation. May be comfortable going forward, especially if they've learned more about the entire case by talking to their attorney. So given this situation, what kind of evidence might the civil attorney have access to that would help the criminal case in this situation? And that evidence might include such things as photographs, witnesses, communication between the parties or between the parties and other witnesses, medical reports, and police reports. That's some of the available evidence in the universe of this case. So some of the helpful evidence or leads might be non-testimonial statements. Remember, Cindy told her attorney that she did tell her mom and sister about the abuse, and they've seen her with bruises, and that was never disclosed to the prosecutor. So that is something that the civil attorney, with her client's, his or her client's permission, can disclose to the prosecution so they can go out then and interview the mom and the sister. If things change later and Cindy is not able to go forward in the case, or even if she does testify, that evidence can come in. And it can either corroborate her testimony when she's testifying about the history of the abuse, or it can come in on a standalone basis, whether Cindy is testifying or not. There may be others as well. And remember, we do have to satisfy a hearsay exception, so it's going to have to come under something like excited utterance or statement of then existing mental, physical, or emotional condition, statements of intention, those kinds of things. So it has to satisfy a hearsay exception, but there may be other people besides her mom and her sister that she confided in. Maybe she ran to a neighbor's on one occasion. So it's worth asking those questions. There's also evidence potentially that would support a finding of forfeiture by wrongdoing if Jason decides to engage in intimidation tactics and frightens Cindy to the point where she doesn't feel comfortable testifying. And that includes that evidence of isolation, ongoing abusive conduct, possible witness intimidation. And the civil attorney should always find out what kind of communication has been going on from the jail. Is Cindy visiting him in the jail? Is she receiving phone calls from Jason? That kind of information can be really helpful to the prosecution because jail calls are often recorded, and they may be able to obtain that. And with some of that evidence, it's going to minimize the burden on Cindy. Even if Cindy testifies in court, she is not going to be as responsible because there's going to be so much additional evidence that the defendant has provided himself, in effect, by making those phone calls. Other helpful leads include this information about the neighbor who called the police before. If we get that information, the prosecutor can go out or send an investigator out to interview the neighbor who may have heard other incidents. That may be the only one that the neighbor called the police about, but they may have other information. And what are we going to do about that gun in the attic? Cindy is scared by that, and we know how serious and how much having access to a gun, a firearm in particular, as opposed to other weapons, can increase lethality, the risk of lethality in these cases. So we can take some kind of action, if possible, to obtain that gun and at least hold it for safekeeping. And we may have information available that will bear on bail conditions. What's going to minimize the risk to the victim as this criminal case proceeds. So with the victim's consent, we can share that kind of evidence and leads. We can talk about the victim's willingness, current willingness to participate, whether they are feeling pretty comfortable about it or not. And we can coordinate the communication about the criminal as well as the civil case and talk about the availability of compensation, advocacy, and other services that may help the victim to be safer and to keep her at the center of all these criminal and civil proceedings. By coordinating our efforts, we can provide a more holistic and supportive legal assistance to our victims. We can make sure that everyone involved in her legal proceedings understand the context of those proceedings and how one may affect the other. And it's going to promote an overall victim-centered approach. So going forward, what we want to take away from this is the value of building relationships with professionals on the other side of the civil-criminal divide. It's interesting. In some small jurisdictions, you might have a lot of practitioners who do a mix of criminal and civil law, and they may be aware of a lot more that's going on than in some of the larger jurisdictions. In my jurisdiction, there wasn't a lot of crossover. There was a civil bar and a criminal bar and not a lot of crossover. So it's important to get talking to each other. We want to start sharing evidence when it's appropriate and when it's consistent with the victim's wishes, again, to promote that victim-centered response. And we want to be educating each other about how we can improve victim safety and offender accountability. And that is what we have for today. We didn't have a lot of time for questions, but anyone who has questions, please feel free to email me or to access any of the resources on our website. And I thank you all very much for joining us.
Thank you so much, Terry. I want to thank both Terry and all of you in attendance for your participation and for your dedication to increasing victim safety and offender accountability in your communities and across the country. When you exit iLink, as Terry mentioned, we really do encourage you to visit our website at www.equitasresource.org, where you can register for future webinars and training events and review additional information about Equitas and access all of our resources. You will also be receiving a follow-up email, which will have a link to a SurveyMonkey evaluation for today's webinar, and will also include a copy of the PowerPoint presentation and Terry's full biography. Please respond to the email if you are interested in CLE credits. And also, please remember that Equitas is a 24/7 technical assistance provider, and we're available to respond to questions, concerns, training needs, and other requests as they relate to the prosecution of violence against women. So on behalf of Equitas, thank you all so much for participating in today's webinar.